Welcome everyone to the 6th informational webinar as part of the UNCITRAL Working Group 3 process on investment arbitration reform. Today's theme is shareholder claims and reflective loss, and the event is co-hosted by the UNCITRAL Secretariat, OECD, and the ISDS Academic Forum. My name is Malcolm Langford, and I'm a professor at the University of Oslo, Pluricourt Centre of Excellence, and I chair the Academic Forum, which is a diverse and inclusive group of 100 scholars that seek to provide research-based analysis to states in the Working Group 3 process. Today, I will be your moderator. In fact, a moderator from a moving car. Not only that, we now use the webinar version of Zoom, which is a little different than normal Zoom. Only the videos of those present and on the panel, and those asking questions orally, will be shown. 3 practical things before we start. When we come to the discussion stage, if you wish to speak and ask a question, put up your hand and you'll be promoted to the panel. If you wish to ask a written question during the course of the entire session, please do so in the question and answer section. And that seemed to work quite well last time. You can also use chat to ask a question. Thirdly, the meeting will be recorded. And we hope that's fine with all of you, and we'll be posting it on YouTube after the event. Without further ado, I'll hand over to Anna Jabin-Brett, Secretary of UNCITRAL.
Thank you very much, Malcolm, and welcome to all the participants that are already online and those that are in the process of joining us. I see that the counting of numbers is going up and up in spite of the topic being fairly technical. But we are looking very much forward to the discussions and to the presentations, first of all, and then to the discussions and question and answers. It gives me great pleasure to open this webinar because it's the first one that we're doing together with our good friends and colleagues from the OECD. The OECD has been actively supporting the Working Group 3 process, and we are really happy to be able to, that it also materializes in a joint event. So last week we had many joint webinars together with Exid on the Code of Conduct. So this week we are with the OECD, another one of our dear partners. So thank you very much for joining forces with us and for contributing so positively and recurrently in the deliberations of Working Group 3. I am pleased to welcome also all our speakers who are going to share their experience, their expertise on this topic, which takes a bit of time before you get your head around it. But we have the world best, the best experience in the field. So I'm really looking forward to the discussions and deliberations. Without further ado, I give the floor to my dear friend Anna with one N and 2 A's, Anna Novik from the OECD. Thank you.
Anna, you are muted. We cannot hear you.
I think, okay, perfect. Now, thanks a lot, Anna and Malcolm. I think the OECD is very, very glad to organize this webinar on shareholder claims and reflective loss with UNCITRAL and the academic forums. Many international organizations, including the OECD, have made a call for reforms, for treaty reforms, and we are very, very glad that governments are engaging in this reform at the UNCITRAL. And we have supported this process, and we will continue supporting this process because this is something that we think that is valuable. We are also pleased to see that the work at UNCITRAL could also use work developed in other international organizations. This is also, it's good for efficiency, I would say, but also this particular topic we have been working in the OECD that is, you know, the FOI roundtable that is broader than the OECD members, and mean that it's this experience we can bring here, and then we can move the agenda from this previous experience. As it mentioned in the document that was circulated for this webinar by UNCITRAL, The shareholder claims and reflective loss affect different areas of concerns identified by the working group 3, and we hope that the good discussion and exchange today help to move and advance this agenda. Very brief because we don't have too much time and I want to have the engagement discussion here.
Thanks very much to both Annas, and now to Shane Spilisi, who is the chair of Working Group 3 at UNCITRAL.
Thank you, Malcolm. Distinguished delegates, good morning, good evening, and good afternoon to all. It gives me great pleasure to welcome you to, as Malcolm mentioned, the 6th webinar that has been jointly organized by the Academic Forum and the UNCITRAL Secretariat, this time in cooperation with the OECD. And as distinguished delegates will recall, part of the mandate, part of the approach of the working group is to work with other international organizations to ensure that the work of the group is efficient and avoids overlap. And one such area where we have benefited from the work already done by other organizations is that of reflective loss and shareholder claims. As Anna Novick said, this is something that the OECD has been working on for a while. Now, this is a subject, these are subjects we have yet to directly address in depth in our working group. It was, in fact, another one of the topics that would have been covered in our April session. We have further detailed information on these topics in 2 papers prepared by the Secretariat for us. Working paper 170, specifically on shareholder claims and reflective loss, and working paper 193, which addresses the broader issue of multiple proceedings and counterclaims, but does contain parts on shareholder claims and reflective loss as they play in there as well. We also have, as mentioned, the benefit of a significant amount of work and research done by the OECD. This work includes papers titled Investment Treaties and Shareholder Claims, Analysis of Treaty Practice, Investment Treaties as Corporate Law, Shareholder Claims and Issues of Consistency, Investment Treaties and Shareholder Claims for Reflective Loss, Insights from Advanced Systems of Corporate Law, as well as a presentation on claims for reflective loss under the investment treaties. All of these papers are found on the online resources page of the UNCITRAL Working Group 3 website under the Selected Research Materials heading. And if you simply scroll down, you will see a number of papers submitted by the OECD. Reflective loss and shareholder claims in general do not have the same profile as other concerns, for example, as concerns about conflicts of interest or unjustifiably inconsistent decisions. And that is because, perhaps, as our distinguished secretary mentioned of UNCITRAL, it is not quite as easily grasped without a bit more understanding of various systems of law, including corporate law. In working paper 170, the Secretariat explains that a reflective loss is an indirect injury suffered by the shareholders of a company when the company itself suffers an injury. Generally, in our domestic corporate laws, as well as other systems of law, claims for reflective loss are in fact barred. And instead, the corporate entity that suffered the loss, rather than its shareholders, are required to bring the claim. Such claims are barred, we are told, for a number of reasons, which we may hear further about today. And those reasons include concerns about ensuring the fundamental legal separation of the corporate entity from its owners, and protecting the rights of other interest holders and corporations like debtors, among others. However, despite the shared approach in our domestic systems, shareholder claims for reflective loss have often been permitted in investor-state dispute settlement by tribunals. In addition to other impacts, such as those on the interests of others in a corporation, the ability to bring claims for reflective loss in ISDS can lead to the possibility of multiple claims as well. For example, a corporate parent company of a local investment could bring a claim for a measure under one treaty And then the shareholder owners of that parent could bring claims related to the same investment and same measure, but under different treaties. And obviously this would all ultimately benefit the same interest holders, the shareholders. In the working group, it has been said by some delegations that conflicting outcomes were more acute in situations of multiple proceedings. And it has been said that these multiple proceedings could therefore contribute to unjustifiable inconsistency, to increases in cost and duration, and to distortions in the balance of interests between various stakeholders. The impacts of reflective loss claims by shareholders have been said by some to stretch across nearly all of the concerns that we have identified as warranting reform in ISDS. Now, we have heard from some delegations in the working group, and we'll hear from them again today, I believe, about some of the tools that they have developed in more modern treaties to address concerns about reflective laws. These include defining the terms investment and investor in certain ways, limiting the standing of investors to claim for only certain types of damages, waivers and stays of proceedings, consolidation, coordination, and joinder, and provisions aimed at preventing abuse of process. Once we are able to return to the working group and consider these tools and other possible reforms in how we respond, if at all, to the fact that reflective loss claims have been allowed by ISDS tribunals, there will be a number of tensions for us to resolve and interests to balance. For example, we will have to consider how to balance addressing the concerns about shareholder claims and reflective loss with the protections afforded to shareholders in investment treaties. We will have to consider the fact that different treaties have potentially different coverages and that they can be involved in disputes about the same measures. We will need to address how certain tools might function in light of the need for consent to arbitrate and the impact that such tools might have on questions of party autonomy. And so with that, let me turn back to our mobile moderator today to begin our informal introduction to these issues, these concerns, and these questions. And while these informal discussions today will not replace discussions in the working group, I hope that they will be informative for all on, as what Anna said, is a very technical topic. And as such, will provide us new and useful information so as to facilitate our efficient and effective use of working group time when we can resume our deliberations. Thank you. Malcolm.
Thank you very much, Shane, for the overview, and welcome now to our panel session. As Shane has already indicated, we have a wealth of expertise on the panel today. And first and foremost, we have David Golkodja from the OECD, who has researched the topic for many years. And we'll start off with a presentation, and then we'll move on to the academic forum paper and experiences from 2 countries with their treaties and arbitration. So first, David.
Great, thank you very much. I'll see if I can share my screen here successfully with you. One moment. So I'm very pleased to have an opportunity to discuss reflective loss and shareholder claims in ISDS with you. And I'd like to thank UNCITRAL and the Academic Forum for the excellent cooperation. This is the outline from a side meeting presentation I did in Vienna at the last working group meeting. Given limited time today, I'll mainly address the first 3 points. I'll start with the contrast between normal corporate law and the unique ISDS interpretation generally allowing reflective loss claims. This is a fundamental point. It's critical to see in the first place how far ISDS has moved away from normal principles. Once the fundamental change is understood, we can discuss the policy reasons for normal law, the consequences of the ISDS approach, whether the ISDS approach makes sense for you and your government. Second, I will look at how allowing reflective loss claims generates multiple potential claims for the same injury, and expands the scope of ISDS. Multiple potential claims of different sorts, with many consequences. The third issue I will address is how reflective loss claims allow for extensive treaty shopping and forum shopping in ISDS. This has broad relevance for reform, and in particular to whether reforms agreed at UNCITRAL would be effective in ISDS in practice. If treaty shopping can allow claims to avoid treaties reformed through UNCITRAL work and to access unreformed treaties, much effort may produce limited effects. So let's turn to the contrast between domestic law and the unique ISDS interpretation. Here we see the situation in domestic law. Please look first along the bottom of the slide. Here we have a government. It's allegedly harming a company. The company has creditors. Who are creditors? Lots of interests: banks, workers, trade creditors, tort victims, bondholders, tax authorities, Social Security administrations, many people. Above, the company has shareholders. But let's focus on the bottom row for now. We have a government injuring a company. Under normal corporate law systems, the litigation story generally stops there at the bottom row. Four aspects are worth noting. First, only the directly injured company can claim. There's a single case, the claim belongs to the company, any recovery in the case comes to the company. Second, shareholders have no claim against the government. They suffer reflective loss when the company is harmed, but they have no claim. They must rely on the company recovering. The no reflective loss principle is shown with the thick black line. Third, the claim is the company's to bring, but also not to bring, or to settle. A single settlement with the company is enough for the government to obtain complete peace. It does not have to worry about shareholder claims. If a shareholder doesn't like a company settlement, it can complain to the company, but it can't claim against the government for reflective loss. Fourth, if a shareholder tries to claim against the government, the focus of analysis is often on the type of loss. If it is reflective, derived from a company loss, the claim is barred. This general approach applies under domestic law, but also under general international law and under the European Convention of Human Rights. Here on this slide, you can see that the company claim under normal law protects all corporate stakeholders. Any recovery comes to the company, and all creditors and all shareholders benefit. Let's look at another company stakeholder structure. At the bottom, we have the same basic events. A government is allegedly injuring an operating company called Able. It has creditors, Baker. Above, it has three direct shareholders, Chelsea, Donna, and Frank. Chelsea and Frank are covered by investment treaties. That's shown by the orange shading. Donna is not. Gretel, above, is an indirect shareholder, also covered. And Hansel and Jerry at the top right represent the great unknown, other potential shareholders. They might be covered, they might exist, they're likely to be unknown to the government, and also possibly to Able. Here, the thick bar blocking reflective loss claims is gone. Chelsea can now sue. What are the protection consequences for those who suffer reflective loss due to the injury to Able? Here we can see only Chelsea and its stakeholders are protected by Chelsea's claim. None of the other stakeholders in Able are protected. Now, before we look at additional consequences in ISDS, a word about the general approach I took in this work. It was carried out for over 50 G20, OECD, and other governments with varying policies and interests. I looked in some detail at domestic and general international law, and the policy reasons for the general bar on reflective loss claims, as identified by courts in particular. With regard to ISDS, I was not trying to decide if the ISDS interpretation is correct as a matter of treaty interpretation. Rather, I looked at ISDS cases in general. I then assumed a broad acceptance of reflective loss claims that corresponded to the approach in a significant number of ISDS cases. This does not reflect all treaties or cases, but it reflected an underlying general approach in much of ISDS. It's a useful starting point for policy analysis. And you can find the simplifying assumptions at page 32 of the working paper cited in the agenda. So let's look at potential multiple claims for reflective loss and some consequences. Here we've seen a claim by Chelsea. Here we have two potential claims by unrelated shareholders, Chelsea and Frank, and we saw that Frank wasn't protected by Chelsea's claim. Here are two claims by related shareholders. Gretel owns Chelsea, both are claiming. Here we see a claim by Gretel alone. Now Gretel along with a company claim under a contract or domestic law most likely, and now Gretel and Frank. The key point is that there are now many potential claims, not just one. And the claims here are shown as actual claims, but they're also potential claims. Every time Abel is allegedly injured, its covered shareholders can claim. So what are the consequences of multiple potential claims rather than only a single potential company claim? There are many. Let's look at 6 procedural ones. First, there are substantial additional litigation costs, as underlined by a US appellate court. Allowing multiple claims in a single dispute is contrary to the goal of judicial economy, resolving disputes efficiently. And that's important with an $8 to $10 million average cost for each ISDS case. Second, there's increased inconsistency. Outcomes on issues of fact and law have differed in cases brought by a single owner of shares, such as Gretel, can claim twice using different entities, and it only needs to win once. Fourth, there is perceived unfairness of subjecting a defendant to multiple claims for a single injury. As set out in the leading House of Lords case denying a reflective loss claim, in that case, Lord Millett underlined that, quote, justice to the defendant requires the exclusion of one claim or the other, end quote. So either one by the shareholder or one by the company, but not both. So some courts see the very fact of multiple claims as unjust for defendants. Fifth, there's increased unpredictability and barriers to amicable settlement. Under normal corporate law, everyone knows only the injured operating company can claim. It's predictable. In ISDS, neither the government nor investors know who may claim. And the government now needs to settle with all potential claimants to get complete peace. That's harder than just settling with the company. And finally, the ISDS interpretation gives covered shareholders clearly preferential rights over domestic shareholders of the same company. And this is of particular interest for the growing range of jurisdictions seeking to exclude or limit preferential rights for covered investors over domestic investors for reasons of efficiency or fairness. And there may be constitutional equal rights issues in some jurisdictions. Now, a recurrent question throughout our work is whether ISDS is different so that there are policy reasons for a different general approach to reflective loss than under normal corporate law. And the answer in our work so far has been no. We have not identified any policy reasons to generally allow reflective loss claims in ISDS when they are generally barred for good reasons under domestic and other law. And you can see a summary of some of the discussion of these issues in Roundtable 19, which is cited in the agenda. Of course, we noted important differences between the domestic law context and international business. For example, under national law, the company generally has access to the same legal system as shareholders. And there may be policy reasons why some foreign-controlled companies engaged in investment may need special protections. Such protections would cover all shareholders and creditors. And sometimes it may be valuable to allow shareholders to seek protection for the company if domestic law systems do not work properly, or to give a domestic company special access to ISDS. And some treaties do that. But it is not yet clear why a general rule should provide individual reflective loss recovery for certain shareholders, while creditors and other shareholders lose out, and while governments face additional costs. Are there exceptions to the general rule? Domestic law. You claim, for example, when the company and its board of directors are not acting in the best interests of the company. But even where a shareholder can exceptionally claim, there are many safeguards that are generally applied. The claim must almost always be brought on behalf of the company and with recovery for the company. There's only one suit, not a combination of multiple shareholder claims and a company claim. The company can be given an opportunity to take over the claim. And there is close court supervision due to risks of opportunistic behavior by lawyers or shareholders. Recovery of reflective loss by an individual shareholder, as in ISDS, is very rare, but there are some exceptions even there. For example, in some jurisdictions, courts have allowed for reflective loss payment to shareholders if the wrongdoers are still in control of the company. But there are still concerns about creditors to be addressed, and other courts have disagreed. Some of these possible exceptions and others may be relevant to ISDS, but a narrow set of exceptions with safeguards is different from a reversal of a fundamental general rule. Let me turn to the issue of treaty shopping using the attribution of reflective loss claims. Here we have the same scenario at the bottom. Government is allegedly injuring an operating company. Let's look at the shareholder structure of Alpha, the operating company. Here, Kappa at the top has control over the whole chain down to Alpha, more than majority ownership all the way down. How does this give rise to treaty shopping? Kappa can attribute a reflective loss claim to its preferred claimant. It can create entities with different nationalities. Here we have nationalities K, E, and D. Each country has a treaty with G, the host government. I mentioned how treaty shopping could negate the impact of UNCITRAL reforms. Let's say countries E, D, and G all agree on reforms. They also ratify an MLI treaty, applying the reforms to their existing treaties. If reflective loss claims are still available, Kappa can easily avoid the reforms by choosing to claim itself. It can access an unreformed treaty between K and G. This slide shows the same situation, but shows how Kappa can also forum shop. Here we show ICSID under one treaty, PCA under another, and Stockholm under a third. Kappa can start two cases using different entities, get two tribunals, and then proceed only with its preferred tribunal, or offer to consolidate only under its preferred tribunal. So reflective loss claims can also give owners of claimants extra powers over adjudicator selection or consolidation. In conclusion, ISDS applies a very different approach to reflective loss than in all other legal systems. The interpretation has many consequences, including for many of the concerns identified by the working group. We're pleased at the OECD Secretariat to work with you and UNCITRAL in addressing the issues in this and other areas of investment treaty policy. Thank you.
Thanks very much, David, for a very useful overview of the key issues. We're now going to move on to the Academic Forum Working Group, who prepared a paper on the topic. led by Julian Arato at Brooklyn Law, and the other authors are Kathleen Clausen, Jamin Lee, and Giovanna Zara. And Julian will be presenting on behalf of the group. And I think you'll also be touching on some aspects of reform. Julian.
Great. Well, thank you so much for having me. And just make sure you can all hear me okay while I get the slides up. All good? All right. So I think this presentation will hopefully follow nicely on David's overview of the main procedural issues and the difficulties, especially in relation to corporate law. And I'm going to try to not be redundant and move the ball a little bit. So this presentation, it follows pretty squarely on research done within the academic forum with Kathleen Clausen, Jamin Lee, and Giovanna Zara, who some of whom are on today and others regrettably could not be. And what I want to do is present the basics of the paper that we've already published and then move the ball into what we're working on now, which are some of the reform options, not comprehensively, but with the goal to just moving the discussion forward a little bit during our great pandemic pause. So the top line of our paper is that the broad availability of shareholder claims, especially for reflective loss in ISDS, is a problem. And in this, ISDS is out of step with corporate law everywhere, but importantly, the result is that it proves inefficient and in many ways unfair for both states and investors. This is not a zero-sum issue. This is something that's quite problematic for all concerned parties in the regime. It drives many of the concerns that we've been discussing here in the UNCITRAL Working Group 3 Forum, especially in relation to inconsistency and dispute resolution. And it also distorts internal basic expectations of corporate law among states involved in these investment treaties. So, what I want to talk about today is first a little bit more about the harms of shareholder claims for reflective loss, building on what David has said. Then I want to speak to some particular situational benefits or possible benefits of shareholder reflective loss in ISDS to try to think about whether or not SRL has any function of value at all in this regime. And finally, I want to turn to reforming shareholder claims in ISDS, where the question of the day is going to be, if reform is desirable, if all of you delegations consider reform desirable, how can any reform avoid losing these particular benefits while resolving the harms? And just to spoil my conclusions, we've found that the harms kind of vastly outweigh the benefits, but there are some potential benefits, but these benefits can be relatively easily captured through reform mechanisms that are far less restrictive on host states, on states parties to investment treaties, and less inefficient for states and investors. So the benefits can be secured through less restrictive means, and that, of course, is the goal of reform. So on the harms of shareholder reflective loss. Allowing shareholder reflective loss claims in ISDS is a problem, both as a matter of corporate law and as a matter of investment treaty law. We've heard a little bit about corporate law from the corporate perspective already. ISDS is out of step with corporate law everywhere, and it really tends to distort the basic expectations about the corporate form for those who engage with corporations and for those who invest in corporations. So as I said, it ends up being inefficient and unfair for all. I'll get into that in a moment. But I also want to address the investment law perspective. The investment treaty regime is developed for particular reasons, right? To protect and promote efficient investment across borders. That's the function here. That's the goal. If the investment treaty regime isn't accomplishing those things, we have a problem. And so I want to point out that the shareholder claims undercuts this basic object and purpose of investment treaties, and then as a result tends to drive many of the concerns identified by Working Group 3 already. So let's start with the corporate law perspective. So permitting shareholder claims for reflective loss undercuts two of the absolutely core functions of the corporate form. Two of the special features of the corporate, the core feature of the corporate form, let me start there, is the separate legal personality. That's largely what corporations is about. It's not just any business entity, it's not a partnership. The corporate entity, the critical feature is that it has a separate legal personality from its shareholders. It's separate from its owners. It can own property in its own name. It contracts in its own name. And the company vindicates its own rights. It makes litigation decisions on its own behalf. All of this is directed by management on behalf of the shareholders, but the company is fundamentally separate. This is corporate law 101, corporate law everywhere in the world. Without that, the corporate form loses its distinctive nature, and most importantly, loses its efficiency power, its ability to efficiently coordinate capital at scale. Another aspect of this, though, and it's a sort of related function of the corporate form, is that the corporation is managed by centralized management. Right? Shareholders don't direct, in general, the activities of the corporation. Part of the arrangement is you have a board structure. There's a set of officers who direct the actions and operations of the company. And these are centralized so as to make the corporate form more efficient, right? You don't have hundreds of shareholders trying to debate every single decision about what the corporation does with its property. It promotes efficient firm-level decision-making, and this protects third parties. Outsiders like states and governments who engage with corporations know that they only need to engage with management, except in extreme cases of abuse, right? They can depend on management's word for contracting, for litigation decisions, for settlement, for anything like that, right? So the idea is this: shareholders buy into a corporation. They own the corporation, but they give up many of the rights to manage the company. By investing in a corporation, shareholders give up many of the rights that they would have normally had to manage their investments. That's the whole point. That's what makes corporations efficient. Okay, so this is much less well known, but part of this, what follows from this in basically every jurisdiction of corporate law, is that there's a dramatic division, as David mentioned, between direct claims and claims for reflective loss. To preserve, specifically to preserve the separate legal personality and the principle of centralized management, corporate law everywhere restricts when shareholders can sue third parties. Right? The company can always sue, right? But when can the owners of the company sue? Well, if their property is separate from the company's property and vice versa, it actually matters a lot when they can sue. So corporate law jurisdictions basically everywhere draw this bright line where shareholders may sue third parties for direct harm to their rights. This might include a restriction on their ability to vote for their shares, a restriction of their ability to get a dividend, rights that actually are part of the share. Right? But what shareholders can't do is sue for reflective loss. They can't sue for loss in share value due to a third-party harm to the firm. If a third party, like a government or a state, does something that allegedly harms a firm, the company can sue, the shareholder cannot. That's part of centralized management. That's part of separate legal personality, a core part. There is an exception. It's not exactly an exception, but there's a sort of alternate route of recovery available to shareholders in many jurisdictions, which is the shareholder derivative suit. But this is really limited. Almost everywhere it's limited. So what happens when management is somehow compromised? The basic expectation is that the firm will recover on its own behalf, and the firm will make the decision of whether it is appropriate to try to achieve recovery, when it's appropriate to settle, when it's appropriate to litigate, etc. But if management is compromised, right? Maybe management is in cahoots with the entity that's harming the firm. Maybe there's a conflict of interest, something like that. Some jurisdictions provide a very limited, usually equitable means of relief through the derivative suit, where a shareholder can step into the shoes of the company and cause the company to sue to achieve recovery, and any recovery would go back to the firm. So it's not really changing separate legal personality, it's just changing who can direct the company to act under very, very narrow circumstances. So that's not reflective loss, and it should not be confused with reflective loss. The basic principle, shareholders can sue for direct harm, not reflective loss. Okay, so what's the problem? Why does this matter? You know, it wouldn't be a very good answer to say, this is out of step with corporate law, and therefore investment treaties should follow corporate law, right? That's pretty formalistic, and we really have to think about what the harms are here. So what would be the harm in allowing ISDS, shareholder reflective loss claims in ISDS? Well, there are some major harms from a corporate law perspective, and there are also harms from the perspective of international investment law. You've heard about the harms from the corporate law perspective, so I'll go quickly. The basic point is that permitting shareholder reflective loss claims lets a claiming shareholder circumvent the basic expectation of all other stakeholders. This includes other corporate stakeholders, in other words, other investors, other members of the same corporate entity, right? It allows shareholders to recover ahead of creditors who normally expect priority on firm assets. So if there's a problem where a state does something that allegedly violates the rights of a company, any recovery, if the firm especially was liquidated at the end of the day, would normally go to creditors first. Creditors expect that in assigning credit to a firm. But the SRL allows the shareholder to jump the line. It also allows treaty-covered shareholders to jump the line in front of other shareholders who expect parity on firm assets. And even among treaty-covered shareholders, if there are more than one different discrete shareholder covered by treaties, it causes all kinds of first-mover problems. There's going to be a race to sue, right, among different actors. This also allows shareholders to second-guess managerial decisions, to litigate or to settle, and this leads to unfair surprises for states who normally expect to be negotiating with management, not potentially hundreds of shareholders. If they're in a situation of litigation, the expectation is that you tend to rely on management's word in the process of litigation, in the process of settlement, and you don't have to worry about the constituent parts of the corporation suing you separately, even once you think that you've settled. So all of this raises the costs of doing business for both states and investors ex ante in the making of investments, where if everybody is suitably aware of these problems, and by the way, I'm under no illusions that everyone is aware of these problems, but if everyone were aware of these problems, it would just make the cost of doing business go up, skyrocket. What about the harms of shareholder reflective loss in relation to Working Group 3 concerns? Well, SRL turns out to be a key driver of many of the concerns that you have identified in this forum. The obvious one is multiple claims, right? And we've discussed that at length already. This leads to potentially unavoidable double recovery situations when two discrete shareholders sue and the company sues separately, depending on who gets recovery first. It may be impossible to say the other actors are excluded from recovery. So for example, if a shareholder gets recovery first for a high dollar amount, that doesn't really mean that the company can't bring its own suit. And it becomes difficult to say that the company recovery in full is not possible because there's been a pro rata recovery by the other shareholders. So this is really quite problematic. And we get into this further in the paper. I don't want to take too much time now. It causes obvious problems for dispute prevention, where management can no longer speak for the firm. It causes problems of duration and cost. More cases obviously creates more problems of duration. Longer cases, litigation over the question of SRL in almost every case, as many of you know. And it obviously leads to problems of inconsistency. So let me skip that. So what about the particular benefits of shareholder reflective loss in ISDS? Well, there are really two situations where there's a potential benefit. The first is that it does provide an avenue for relief when the local entity lacks access to ISDS under a particular treaty due to nationality concerns. Many treaties don't afford the local entity the ability to sue on its own behalf. It's not a national of the foreign state, and therefore SRL, it might be thought, well, SRL actually allows the shareholder an ability to sort of vindicate their investments if a treaty breach were to occur. The other thing is, even where treaties provide for nationality for the local entity, these treaties, the availability of SRL protects foreign owners where the local company can't vindicate its rights for some other reason. Let's say the local company was totally expropriated, or there's a conflict of interest where management was bribed or something like that, where there's a very extreme circumstance which prevents the local company from bringing a claim on its own behalf. The availability of SRL provides an alternative avenue for relief. Now, these are really limited benefits, but they are real benefits of SRL in the context of ISDS. And I would submit that any reasonable reform to the system shouldn't lose sight of the possibility that the ISDS context is different from a national law situation. And because much of investment, there's a great desire among many states to have investment occur through locally incorporated entities, that needs to be taken into account in the process of reform. But I'll say that there are reform options available that capture these benefits completely without causing all of the manifold harms of shareholder reflective loss. And there are three models that one can point to from the treaties that we have already seen, sort of derivative action regimes, such as the Nafta, Articles 116 and 1117, the deemed foreign regimes, like the Exclude Convention, Article 25(2)b, and the possibility of clarifying and expanding the scope of permissive shareholder direct claims. So I'm not going to cite chapter and verse of these treaties. They're available on the slides. Let me just quickly say the point. The old Nafta, I suppose, rest in peace, provided for not only claims by investors on their own behalf, but also claims by investors of a party on behalf of an enterprise. So an investor could step into the shoes under certain circumstances and cause the local company to sue as a company. Even if the company didn't have requisite nationality on its own, the derivative action is a possibility. So that avoids the concern where the local company can't sue and solves many of the problems that we've seen. The problem is that tribunals have tended to interpret Article 116 as allowing both shareholder direct claims and shareholder reflective loss claims. So even if the derivative action was available, all investors just tend to choose the shareholder reflective loss claim, because why go through the hassle of having recovery go to the firm? So to be effective, reform options on the derivative action model should expressly close off the door to shareholder claims for reflective loss. That is a change that is necessary on even the most recent progeny of the Nafta, treaties like the CAFTA, the Chorus. We've just recently seen the Capes case come down, a CAFTA case where exactly this problem arose. The shareholder brought an SRL claim, and the mere existence of the derivative action did not did not close off the SRL possibility. The other possibility is the ICSID Article 25(2)b model, where the treaty can actually provide that a local company, foreign owned, is deemed foreign for the purposes of jurisdiction. That would similarly solve the problems. But here again, recent cases have shown that unless you actually close off SRL, this is considered to be just a mere alternative to a shareholder reflective loss claim, and it doesn't implicitly close it off. The Cube case I can point to recently was evidence of that a tribunal said, yeah, the existence of this clause doesn't really close the door. Okay, last thing I'll say. The last possibility is one can close off shareholder reflective loss claims, but also better calibrate direct claims, right? One can say, look, direct claims is a defined term under our treaty, and it might not have to be limited to things like voting your shares or receiving a dividend. One can define direct claims to include something like total expropriation of the firm, right? And that would create an alternate avenue of recovery for shareholders whose local firm is not able to bring a suit. And therefore you have this sort of typical ISDS problem without opening the door to the flood of multiple shareholder reflective loss claims and all of the problems that entails. And I would just add that this calibration strategy can be combined with the derivative action or the deemed foreign mechanism. And finally, there are many, many other alternatives. This is just sort of a mere survey of some of the options that we've already seen and how very kind of limited tweaks could make them much, much more effective in future treaties. But in future work, we'll do much more to elaborate other options, as I'm sure will all of you. The paper's available here. Thank you so much for your time and attention.
Thanks very much, Julian, and the working group, Cathleen, Julian, and Giovanna, for helping frame the discussion, but also starting to point us in the direction of potential reforms for discussion. So moving from theory to practice, we're going to now hear from two governmental representatives who have a lot of experience with these type of claims. And first up is Sylvie Tabet from Canada. Sylvie. We don't hear you yet, Sylvie.
Right.
There we go.
Hi, thank you, Malcolm. And thank you to the UNCITRAL Secretariat and to the OECD, as well as to the Academic Forum for the great papers they have put together on this complex issue and that have really, I think, helped frame the discussion. A lot has already been covered in the two previous presentations. So I do have a presentation. I will probably skip over quite a few of my slides and move to the more practical aspects. But I did want to start very quickly by situating the issue to the extent that some of the points have not been touched upon by by Julian and David, and talking a little bit about the policy consideration, although that has been to some extent covered, and talk about the practical experience we've had in our Nafta cases and what we see coming out of investment tribunals. All right. All right, so I think the first issue that David had a number of slides on is, and Julian covered again, is what is the shareholder reflective loss and when does it arise? And I think it's been clearly explained, but just so we're all on the same page, we're talking about a situation where a shareholder invested directly or indirectly, and there can be a chain of companies in a corporation in the host state. And again, what is key here is that distinction between the direct damages, which are measures that interfere with the shareholder rights, like share ownership, voting rights, and dividends, and the right to share in the assets in the liquidation of the company. And on the other hand, the indirect damages to the shareholder that result from the harm to the corporation. And what we've seen in a lot of the cases is shareholders claiming for example, when there's been a breach of contract and the contract belongs to the locally incorporated or is with the locally incorporated entity. And so the basic question is, what do we want our treaties to cover? What claims can the shareholders bring? And I'll come a little bit to this later on when I talk about the Nafta model, but it's also important to keep in mind that there may be a distinction between shareholders who own and control the enterprise and the other shareholders. As David mentioned and Julian, I think it's very clear that a number of domestic legal systems prohibit this kind of shareholder reflective loss for good reasons that have already been covered. Our Supreme Court recently, in 2008, reiterated that it was important for shareholders, if shareholders were to bring a claim, they had to establish a breach of a separate legal obligation owed to them and an injury distinct from that of the corporation. And similarly, all of you are familiar with Barcelona traction, which established the same thing in the context of diplomatic protection. And I won't go over it in detail, but there are some interesting passages which are useful to read again from the International Court of Justice decision. And clearly emphasizing between the direct infringement of the shareholder rights and the difficulties or losses resulting from the situation of the company. So the question is there a different rule for investment agreements? And the International Court of Justice, some have suggested that the International Court of Justice has found that there is, and have some investment tribunals in particular have looked to the ELSI decision, where the court recognized the right for the US to bring a claim on behalf of US shareholders against Italy for measures that Italy took in relation to the corporation. But I think it's important also to remember that the issue in ELSI was the liquidation, the requisition of the assets of the company, and therefore, in some way, the measure interfered with the shareholders' right to participate in the liquidation of the assets of the company. Now, what we have seen in investment tribunals' decisions is basically a clear setting aside of ICJ diplomatic protection distinction or rejection of shareholder reflective loss, and to allow shareholders to bring claim. And they have done that. Specifically, the reasoning has been based on three broad elements. First, they have looked to the definition of investment and said, well, it includes shares, and therefore shareholders are protected and benefit from the treaty protections. And then because they conclude that the investment agreements permit shareholders to bring claim and offer them a remedy, they just jump directly to the analysis of whether they've suffered damages. So it's pretty simplistic. And some tribunals have then tried to address related issues that flow from their reasoning on their analysis of damage. Now, again, because they have realized that many of the investment tribunals realize that this is simplistic and can cause problems, in particular with respect to double recovery, and they've acknowledged this and tried to address it in their analysis of damage. And similarly, what we're seeing is the introduction of some abuse of process type of analysis where a corporation and a chain of company tries to take advantage to bring multiple claims for the same harm. But this is a bit unsatisfactory in where it leaves us. It really only addresses part of the issues. In fact, very few tribunals have completely rejected shareholder reflective loss. There is one recent case in Lotus versus Turkmenistan where the tribunal did kick out the claim because it found that the request for arbitration did not articulate claims that did not derive exclusively and were not wholly overlapping with the contract claims belonging to the locally incorporated company. So I think the policy considerations, again, have been somewhat touched upon. I think an important question is, did treaty parties to investment agreements want something different? And is there a reason for wanting something different because shareholders are in a different situation, often or not often, but in a few countries, shareholders, for example, can be required to invest as minority partners in an enterprise and therefore could be left without any significant protection. Is that a situation that investment treaties intended to address, and would they, how would completely banning shareholder reflective loss in a clearer way deal with those types of issues? Related questions are whether we want to give any protection to some of the minority shareholders. And I note that some of the recent treaties, for example, exclude portfolio investment from the scope of protection of the treaty. I think that's a bit of a separate question. And it is, in some way, it addresses partly the issue of shareholder reflective loss, but it also potentially completely removes legitimate protection for a minority or portfolio investors, for example, if they're discriminated against vis-a-vis other portfolio investors. So just moving to the way that Canada has tried to address these issues in its treaties, and I talk about the Nafta model, but given that we're July 2nd, and there's no longer any Nafta, I think the approach is certainly reflected in a number of treaties, including CPTPP, CETA, and a number, I know for Canada, a lot of our recent bilateral investment agreements are also modeled on this approach. And basically, to summarize it, the shareholders can bring claims on their own behalf for their direct losses. And they can also bring a claim on behalf of the corporation, but only if they own and control the enterprise. And in that second case, they can actually claim for damages to the corporation, but the award will be paid to the enterprise itself when the claim is brought on behalf of the corporation. So it addresses a lot of the corporate law issues, creditor, who gets to access some of these, some of the award in priority, etc. Another important feature of this model is that there is a waiver that is required by the shareholder when they bring their claim, as well as by the enterprise, if the claim is for damage to the enterprise. And this way it avoids the multiplication of the multiplication of cases that are being brought, including in domestic and other fora. Okay. Now, the Nafta parties have, in the context of their various cases, this has been actually addressed quite a few times by the Nafta parties in a number of disputes that have been brought, often by shareholders, sometimes by under 1116 and 1117 together. But in some cases, they were the cases were brought by minority shareholders as well, so they could not have brought it under 1117. The GAMI case is one example, and the three parties were basically took the same position on the very clear distinction between 1116, which allowed for claims for direct damages, and 1117, which allowed the shareholder to bring the claim on behalf of the enterprise only if it owns or controls the enterprise. And the party said there's a clear distinction between the two, and you have to respect it, and also suggests that the shareholder cannot claim for indirect damages to the corporation. Unfortunately, the position was also repeated in a number of cases like Bilcon, and unfortunately the tribunals have been rather inconsistent in respecting the distinction between direct injuries and shareholder reflective loss. In GAMI, for example, the tribunal rejected the application of Barcelona traction, saying that's diplomatic protection, and found that the minority shareholders could bring claims for measures affecting the local corporation's sugar mill. Now in Bilcon, the tribunal took a bit of a different approach in that it recognized that shareholders could only bring claims for direct damages, but arguably it failed to apply it properly. At least that's what Canada's position was. And if you look, I just put two extracts from the tribunal's award, where the tribunal recognized this distinction and says that 1116 is not meant to allow reflective loss. And the tribunal relied in large part on the common position of the Nafta parties in that respect. But then it went on to say that basically the investor was the one that suffered from the loss of opportunity resulting from the corporation's treatment during the environmental assessment process of its project. So obviously that was an interesting way of circumventing what the tribunal saw as the common party position of the Nafta parties, and through the application finding that was indeed a direct loss to the shareholders that was at issue here. So I think that flows well from Julian's point about there is a need to explain a little bit more clearly, or to think about what do we mean when we say direct damages. And it's somewhat difficult to do in a treaty, but I think this discussion has to be combined with an examination of what are the rights of the shareholder that we want to protect. And here, the opportunity to make money out of a project from the corporation, it was not a shareholder right that was directly affected by the measure. So again, various considerations that we want to think about that have already been covered, so I will skip quickly over them. And maybe we can come back to some of this if there are some questions later. But I do want to conclude by talking a little bit about the reform options and have offer some thoughts on what is really possible here given the issue that we're confronted with. And I think when we look at the investment agreements, there are very few treaties that actually try to address shareholder reflective loss explicitly. I found like one example, perhaps in the China-Mexico BIT, but it's somewhat partial. Again, CETA and CPTPP and other treaties try to do it through the 1116, 1117 distinction and allowing derivative claims and with waiver provisions, but it doesn't specifically exclude or explicitly at least exclude shareholder reflective loss. And as the chair earlier referred to, I think if we're talking about some kind of clarification or interpretation of the existing language, that may be difficult depending on the existing, the language in the existing treaties. So it may be possible to do, as the Nafta parties, for example, have done, to make it very clear what the position is, that indirect or shareholder reflective loss are not allowed, and there could potentially be some exploration of what do we mean by direct shareholder claims. But it may be much more difficult to do in other more broadly worded treaties that just allow shareholders to bring claims for any damages they have suffered. So it may be necessary, I think, to look at something a little bit more, if we go down this road, to look at something more in the nature of an amendment, potentially through a multilateral convention, if that wanted to be addressed directly. And otherwise, we would be looking at tools to mitigate the effect of shareholder reflective loss. But those are just some initial thoughts, and I very much look forward to the discussion.
Thanks very much, Sylvie, for giving us, again, also an overview, but also a number of reform options to think about, and also some practical examples from different cases. Last but not least, we have Laura Antonella Marquez from the government of Argentina, which has also had a lot of experience with shareholder claims. The word is yours, Antonella.
Thank you very much. Good morning, good afternoon, good evening to all. I would like to thank the UNCITRAL Secretariat, the Academic Forum, and the OECD for giving me the opportunity to participate in this webinar. I am very glad for this possibility to discuss a topic that is of the utmost importance for the Argentine Republic, and I welcome the opportunity to share the Argentine experience on this matter. Shareholders' claims for reflexive loss have been proven to be a very dangerous systemic problem in ISDS. I would not like to go through all the undermining consequences of such claims because I think it has already been very well covered by the previous speakers. I just want to highlight the policy concerns raised by reflexive loss related to consistency, judicial economy, risk of double or even multiple recovery, increase of the risk of forum shopping, and also distortion of corporate law. ISDS tribunals have been continuously required to adjudicate on the question of indirect or derivative claims filed by shareholders, and they have been asked to do so on the basis of first-generation VATs, which provide very little guidance on the issue of the scope of shareholders' claims. The Argentine ISDS experience is full of examples of derivative claims. The Argentine government has consistently raised objections on indirect or derivative claims, which have been systematically rejected in numerous decisions. CMS, Azurix, Enron, LG&E, AES, US, Pan American, Camuzzi, Continental, Gas Natural, Siemens, Saur, Vivendi, Impregilo, and so on. However, following the unsustainable approach of CMS case, several tribunals have allowed shareholders to bring derivative claims, basically in respect of the reduction in the value of their shares. Tribunals have thus completely ignored the basic principles governing the right that, in domestic legal systems, a shareholder acquires through an investment in shares, and have also disregarded the possible disruptive effects of allowing any shareholder to bring any claim in respect of any prejudice caused to the company, potentially creating an endless chain of claims. I would like to draw your attention to some aspects that most of these cases have in common. First, non-application of Barcelona traction case. A number of tribunals have rejected Argentina's assertion that shareholders' claims in relation to damages suffered by the company are admissible under general international law, either by arguing that Barcelona traction is concerned only with the exercise of diplomatic protection, like in CMS, both US, LG&E, Azurix, and Enron, or simply by asserting that ISDS cases are not situated at the level of general international law, but at that of treaty law, like in Continental, Pan American, and Total. But the legal arguments of the ICJ in Barcelona traction in relation to the rights of shareholders are made independently of the fact that the case concerns an exercise of diplomatic protection. In this regard, it is also important to take into account that VATs are not a self-contained legal system that can be separated from general international law. Second, tribunals have typically confused the question of whether the claimant had a protected investment under the applicable VAT, the question of whether the rights of the shareholders were directly or indirectly affected by the alleged breach. For instance, in the Enron case, the Argentine Republic objected to the admissibility of the claim on the ground that the claimants did not have the rights upon which they based their claims. The measures in question directly affected only TGS, a company incorporated in Argentina in which Enron participated through investment in various corporate agreements. The tribunal argued that the question of jus standi was inseparable from the determination of the claimant's status as a protected investor, and concluded that, under the broad provisions of the applicable VAT, claims made by investors for protecting their interest in the qualifying investment were admissible. A similar argument based on the breadth of a definition of investment was raised by other tribunals in Sempra, Total, Continental, Tribunal, Impregilo, Telefonica, Gas Natural, and so on. But the Argentine Republic had not questioned the fact that an investment in shares qualified for protection under the applicable VAT. It asserted that claims can only be made in respect of measures directly affecting the economic rights of the shareholders, as in the event of a denial of the right to any declared dividend, and not in respect of the measures that affect the corporation as a separate legal entity. Furthermore, Argentina raised a concern about the fact that if minority shareholders can claim independently from the affected corporation, any shareholder making an investment in a company that makes an investment in another company and so on would invoke a direct right of action for measures affecting a corporation at the end of the chain, triggering an endless chain of claims. When confronted to this argument, the tribunal noted that while investors can claim in their own right under the provisions of the treaty, there is indeed a need to establish a cutoff point beyond which claims would not be permissible, as they would have only a remote connection to the affected company. Consequently, the tribunal proposed that the test of an invitation be adopted, inquiring whether the investor was invited to invest in the host state. This test used the language of Argentina's objections to jurisdiction in impregilo, only needs to be stated to demonstrate that it is wholly subjective and patently unworkable. And finally, a cautious approach of tribunals to the concern about the possibility of double or even multiple recovery. This approach was reflected through a variety of arguments. For example, that double recovery was not likely, it was the case in Sempra, that it was a theoretical rather than a real practical problem in Pregilo, that in any case, an eventual final award could be fashioned in such a way as to prevent double recovery, Suez, BP, American Production Company, AWG, or even that such a risk is inherent in many investment disputes and does not in any way constitute a restriction on the jurisdiction of the constituted tribunal pursuant to the applicable BIT, Urvasa. The same point of view was expressed by the Urvasa Tribunal regarding potential conflict of interest between shareholders' BIT's claims and the company's creditors. There is a certain randomness in such considerations, which deviates from the fact that double recovery should be prevented through a clearly defined legal basis. Naturally, all this case law experience had led us to the question of how we deal with the problem of reflective loss claims. And I have to say that unfortunately, we have not found a magic legal formula yet, and I don't think there is one. Recourse to international principles such as res judicata, lis pendens, and foreign inconvenience, or to procedural mechanisms such as the consolidation of proceedings, can have a positive impact on this matter. Hhowever, such remedies are not conclusive when dealing with the issue of reflective loss. In that sense, acknowledging through specific treaty language the particular nature of derivative claims in a system that seems to have rejected from the root the no reflective loss principle generally recognized in domestic law and general international law would be a good mitigating approach. Potential mitigating effect could be achieved by including claim limiting provisions and waiver provisions in BITs. This approach could give tribunals more guidance in respect of the scope of shareholders' claims and also have a significant impact in limiting the unbounded world of potential claims for reflective loss. Argentina has included in its modern BITs provision specifically allowing to file claims to arbitration on behalf of a local enterprise owned or controlled by a treaty covered shareholder, provided that both the claimant and the legal person waive the right to initiate or pursue any proceeding before an administrative or judicial court under the laws of either party or other disputed settlement mechanism with regard to the measure in question. Having that in mind, a positive way to continue this process of reform undertaken by Working Group 3 in relation to claims for reflective loss would be to analyze and propose the most adequate language for that kind of provisions. This, without losing sight of the fact that, as I said at the beginning of my presentation, reflective loss is a systemic problem in ISDS, thus requiring a systemic approach through a comprehensive ISDS reform. Thank you very much for your attention.
Thanks very much, Antonella, for giving also both a theoretical and a practical perspective on different cases and helping us think about reform. We're now going to open up for questions and comments, and I hope the technical nature of discussion hasn't scared you too much, but our question and answer button is open, as is our chat function. But first I'll give the word to any of the panelists if they want to respond to the presentations of the others. And you can see everybody here now. And while you're thinking of a question, I have got a follow-up question for Antonella and Sylvie. You talked about the systematic nature of double recovery claims. How many cases against Argentina and Canada have you experienced these sort of claims? And then perhaps David and Julian might be able to give us perspective on the global dimension of the amount of claims of this nature. Antonella?
I think I've lost count of the cases I've had. I think that nearly 60, because almost all the cases that we had were filed by shareholders. So, and the Argentina's jurisdictional objections were always rejected by tribunals. I think there have been hybrid cases in which the tribunal rejected part of the claim of the shareholder because it was an indirect claim, but it's like I can think just of one case. And then there have been other cases in which we reach an agreement with the company before the possibility of the tribunal to resolve the question.
Very good. Sylvia?
Well, we haven't really had the situation of having multiple cases relating to the same damage claim. So that hasn't been so much the issue, but we've had a lot of situation where tribunals have been very approximate in approaching the corporate form. For example, early on in SD Myers, they said some of the shareholders, some of the family members weren't really shareholders, and they grouped together claims to shareholders, to members of the family, and to the corporation into one big amount, and well, not so big, but into one amount. In any event, the point is that tribunals haven't been rigorous in looking at this issue. I think the Mexico is actually facing a number of really interesting cases that highlight some of the concerns and discussion we've been having. If you look at procedural order number 4 in the Elise Grace case, deals with an application by some of the preferred creditors, I believe, to the corporation, and in relation to the claim that was being brought by some of the shareholders, explaining some of the issues that we've been discussing today and the problems that would be caused by allowing the shareholders to jump the queue and have access to settlement or have access to recovery of loss.
Thanks, Sylvie. Julian has a quick response on this.
Yeah, so we've said frequently over the course of this webinar that this is a rather technical topic, but I want to avoid any possible sense that this is a narrow topic or one that doesn't come up very much. It's actually cuts to the core of most of the cases that we see, and it can be a little bit misleading why. And so I just want to sort of separate two scenarios for everybody. There's really two types of situations that the SRL comes up in. The one is where you have a corporate family, mostly wholly owned entities, lots of different entities under kind of common control. And the other situation where it comes up is with a company with discrete shareholders, a publicly traded company that has different kinds of shareholders. And it's a huge problem in both cases, but the problems are different, right? So a state who is basically engaged with a corporate group where it's all wholly owned entities, like in some of the Canada cases that Sylvie was mentioning, you're not going to necessarily come up with the multiple claims problem. And where that does come up, it can look like bad faith, as in the recent Orozco case, where one company is just directing dozens of subsidiaries to bring claims under separate treaties. That's pretty obviously a problem, right? But the problems that arise in that situation more commonly are the problems of not being sure who you're engaging with, the problems of negotiating with one entity or another, shifting sands and negotiating with the company, and just the basic expectations of who you're dealing with and what types of claims are going to be available down the line when a subsidiary invests in your country, when the corporate group might be able to do all kinds of things, is a problem. The treaty shopping problem also arises with the corporate groups. You might not think you're engaged with a treaty-covered entity, only to find out later that you are. So those are the kinds of problems there. With the publicly traded companies, where there's all kinds of discrete shareholders who don't have the same interests and might not share the interests of the company as a whole, that's where you start to see the corporate law problem. So these are really different scenarios. And in counting how often these types of situations come up, it's sometimes easy to dismiss that it's that often if you only focus on one slice. But if you look at both types of claims, the treaty shopping, the total corporate group, versus the publicly traded entity with lots of different stakeholders, it starts to cover most investment treaty cases, or a huge amount of them.
Thanks very much for that. I'm going to give the word shortly to David, but there's many questions coming in for him, so I'm going to give him a moment just to to reflect on those. And we have our Felix Stefik from the University of Cambridge, I believe, who's raised his hand and will ask a question. Felix, if you unmute, there we go.
Yeah, thank you. So I'd like to just comment and essentially say that I agree with, I mean, the general kind of consensus that at least appears to form on the panel that reflective loss is to be avoided. And I would just I'd like to add 2 or 3 reasons in addition that I see. One is insolvency. So reflective loss and such claims may arise in particular when the company is in financial distress. Now, you know, in addition to corporate law principles, you've got the insolvency law principle that in the twilight period, financial distress, the corporation may not pay dividends or distribute to shareholders. But in essence, this is what happens in the reflective loss claim situation. And then moving on to this, so how will creditors react to this? They will anticipate it, at least those who are rational and informed, and they will charge a risk premium when extending credit. Now, this will make credit loans more expensive in the country. And Julian and his colleagues mentioned this on their slide. They pointed to the ex-ante effects of those clauses. But, you know, so I'd just like to expand a little bit more on this. Now, if creditors will anticipate loans, credit will get more expensive. And the same will happen to equity, because those who are not covered will also anticipate that money will be diverted from the firm, and that is the claimant's gain will be their loss. So equity will get more expensive, or equity will not be provided. And this covers local investors, local equities investors, and non-covered foreign investors. Now, if you take this together, then this is why I agree with the presentations that the advantages of introducing those ISDS claims are actually lower than the sum of disadvantages you create, because credit gets more expensive, non-covered equity investment gets more expensive, and so the ultimate aim for establishing this framework will not be reached, and that was to increase investment in the country. And in addition to this, it's not just, and I think one major issue is that not just where then actually a claim will be brought will this happen, but because creditors and shareholders will anticipate that investors may trade into an arbitrage into such positions, you will anticipate that you may be negatively affected, even if at the moment of investment there may be not such an opportunity in place. So all in all, I think that's why I agree with the analysis that the panel has given. I think the economic disadvantages just outweigh the advantages. And this, I think the disadvantages were probably not seen for historical reasons when this framework was set up. And I think, and I want to conclude with this, that citizens are more and more criticizing such treaties from a moral perspective, and they are asking whether they achieve what they were supposed to achieve. So it's not just an economic issue. I think it's also an issue of fairness and equity that arises, and where the constituencies are more and more aware of. Thank you.
Thanks very much, Felix, and maybe members of the panel want to respond. But first, David, since you've got a number of questions directed to you.
Great, thank you. There's a question about the number of treaties that provide an option for a claim on behalf of the enterprise. It's essentially a Nafta innovation. So the Nafta progeny, as Julian referred to it, are, I think, the principal ones. We haven't counted the number. It's relatively small as part of the broad range of treaties. And as I noted in the treaty shopping slide, CAPA can choose a treaty that does not have that option in a number of cases, unless the government has been very systematic in including it in all its treaties. So there's quite a bit of ability to move the claim away from that type of treaty, just as to move the claim away from other aspects of treaties that may have been reformed. The issue, there's a question about double recovery, whether it's actually occurred. We don't know, but I think if you think about a payment to a 30% shareholder, once that payment is made, what is the company going to recover? Is the company going to recover 100? That's the only recovery that will satisfy the other 70% shareholders. But if it recovers 100, the 30% shareholder gets 30 from the ISDS case plus 30 from the domestic case. Now it's at 60 for a loss of 30. But I think there's a broader problem that was pointed out recently in an English Court of Appeal case. You have, say, Gretel up at the top of one of my slides. And Gretel has people on the board of Able, which is the operating company that is injured. The reflective loss claim by Gretel is often more attractive than the claim by Able to Gretel. They would rather get the money themselves rather than having to try and extract it from the company after it goes to Able. What is Gretel's board representatives, what are they going to do on Able's board? They are conflicted. They really don't want Able to sue. So you have, if you allow the shareholder to sue and the shareholder is represented on the board of the company, you have a serious conflict of interest when that board is trying to decide what the company should do. And that's one of the many reasons why the courts, again recently, have rejected this type of claim, because I think it adds another point to the ones Julian was making about how fundamentally this disrupts corporate law. If you bar the reflective loss claim, the board decides in the interests of all the shareholders. In terms of the number as well of claims, I think one has to recognize how attractive these claims are to shareholders. Domestic law has many, many examples of shareholders trying to argue that they have suffered direct loss and should be allowed to recover, and many, many examples of courts carefully looking through and saying, no, that's reflective, and some cases saying, no, that's direct. So this is this is a very attractive proposition for the shareholder to be able to extract cash from the corporation, because the normal rule is once you buy your share, you can't sell it back to the company, right? You have locked in that asset to the company, and that allows the company to rely on shareholder capital. Once you let shareholders extract it through a reflective loss claim, the company's capital is no longer as secure as it normally is. And that's one of the rationales that the German courts have identified for barring reflective loss claims. One final point, in terms of the number of reflective loss claims in the overall set of what I guess UNCTAD has now calculated, we're up somewhere around 1,000 claims. I think it would be very useful to count the number of claims, but I think we're talking about a very substantial part of the ISDS body of claims. Our governments have asked us to look at the economic aspects of ISDS. High numbers of claims involve high revenues for the arbitration bar. So I think we're looking at a rule that has significant economic benefits for the profession. And I think one can expect views about reform from people who have an economic stake to reflect in some cases that interest. So I think within the context of UNCITRAL, within the context of OECD, where governments are gathered, it is really important for governments to get a hold of this issue and decide for themselves, because I think the likelihood of tribunal evolution in the absence of government action is probably fairly unrealistic given the economic interests at stake.
I would like to add something.
Go for it.
I don't think, thank you. I don't think that it is relevant whether there have been cases of double recovery or not, because I think that the mere existence of the possibility of double recovery is alters the economic behavior of the economic actors, and it can undermine the possibility of the enterprise to settle, or even the willingness of the state to reach an agreement with the enterprise. And then I don't think that solutions that tribunals found were fair. For instance, in the Suez case, the tribunal used kind of later in time tribunal test, because it concluded that to award damages in the circumstances of the case presented no double recovery problem, because the Argentine courts had not granted any recovery to the local company yet. So the tribunal asserted that if it had to award damages in Suez, it was certain that the Argentine government could make the relevant court aware of that fact. And I don't think that kind of solutions are fair. I don't think it's fair for the company to be not to have a fully recovery, because I think David mentioned it before, because there has been a pro rata recovery awarded to some shareholders in another forum. So I think that the mere risk of double recovery is dangerous itself. And well, we've had cases in which finally the company settled with the state, and there was damages awarded to the shareholder in an international forum. So they benefited twice. Thank you.
Thanks very much, Antonella. Sylvie has a response.
I agree with Antonella's comments. I don't think the question is, has there been double recovery? I don't think that's the only issue. There are a number of issues which we've also talked about, including if the shareholder is allowed to recuperate the money and not the company. If the award is not paid to the company, then the company avoids all kinds of liability, and we've talked about creditors. There's tax liability, environmental liability. And we know that in a number of investment cases, those things are at issue. And so to the extent the company is harmed and is able to recover damage, it should also abide by its other obligations vis-a-vis local community and governments. And those are real issues.
Thanks very much, Sylvia. Julian also has a response.
Yeah, thank you. So I've actually just two things I wanted to mention. One, a response to Felix, and another to sort of, I guess, join Antonella and some of her comments throughout the presentation and recently. So on the Felix point, I think Felix's interventions were really important and useful, and I think I want to help to avoid shifting grounds here, right? So there's really only two worlds we could live in, right? There's the world in which everybody is aware of this shareholder reflective loss problem, and there's a world in which it's pretty low salience. People are not aware, states and investors are not aware of it. So in a world in which everyone is aware of it, I completely agree that it will create lots of ex-ante costs for the making of investments, right? It will drive up the cost of credit because creditors will have to protect themselves. It will drive up the cost of equity, as Felix very helpfully noted. All of these are real problems for the efficient conduct of business, which is exactly the opposite of what investment treaties are meant to do. But that's not probably the world that we live in. Probably the world that we live in is one of low salience, where many states and many investors even are, at least at the time of making the investments, not really aware of the investment treaty jurisprudence on these treaties. The treaties aren't particularly clear on this issue, as we've discussed. So what's the problem then is one of unfair surprise, right? States will find themselves unsuspectingly subject to the types of claims that you would never imagine possible under basic expectations of corporate law everywhere. Now, of course, learning is possible. We're learning now, right? So as we move from a world of low salience to one of high salience, it's not the problem that goes away, it's rather the types of problems change. We move from a world of unfairness to one where it's not particularly unfair. Everyone understands the rules of the game. It's just a total waste of time and money for everybody, right? So it's important to avoid straw men with saying, well, what investors really rely on this? Well, if no one's really relying on it, then it's unfair. If everyone's relying on it, then it's wasteful, right? Those are the only two options, as I see it anyway. The other point I wanted to emphasize is one that Antonella made, which is, I think, really important, that these are not problems that tribunals can't deal with on their own. It's structurally not possible under the fragmented nature of our investment treaty regime for tribunals to develop solutions. First of all, tribunal-driven solutions are not likely to be affected in the first place anyway. There aren't, as Antonella mentioned, the kinds of things like res judicata, lis pendens, these are incomplete even if they work, right? But we also have to remember that each tribunal has to figure this out anew, and each tribunal has to deal with the fact that this issue is litigated in every single case. And so tribunals will come up with different solutions that don't quite fit. That's what we've seen in the case law with one another. And so if you think about it ex ante, when you're thinking about litigating, when you're thinking about investing, when you're thinking about inviting a state to invest, an investor to invest, it's impossible to predict what tribunals are going to do. So yeah, look at the recent Orascom case where there's a chain of entities bringing suits under lots of different treaties. The tribunal recognized this as abusive. It ruled on abuse of right. It kicked out the claims, right? And it did its best to resolve the case. I have no criticism of that tribunal whatsoever. It's just that this can't help ex ante because lots of other tribunals went the other way. So we can't say there's an abusive process rule in investment treaty arbitration. The most you can say is, well, you better brief that and sub-tribunals might get it right, right? So this is something that if there's a desire to reform it, reform must come from governments. It can't be something that we say, well, tribunals will figure it out. They can't. It's structurally not possible.
Thanks very much, Julian. Does Sylvie also have a response to that? You had your
No,
hand up.
I have no further comments on that.
Okay, you had your hand. But David does. I see David.
Just one element I didn't have a chance to address because 15 minutes is short given the number of issues, and we've seen some additional ones come out. But we see in some cases that the state government opposes the reflective loss claim, And the arbitrators say, well, we can figure out the reflective loss. We're not going to give the shareholder, anything it isn't entitled to. We're going to look at, everybody from Baker through Chelsea, Donna, and Gretel, Hansel, some people we may not even know about. We're going to figure out how much everybody lost. And as I mentioned, the creditors, bondholders, they all have different rights. You may have secured creditors, you may have unsecured creditors. Big international investment, there's a lot of creditors with different rights. Arbitrators tend to have, a high degree of self-confidence in their ability to sort that out. But I think one needs to recognize how complex it is to try to figure out in a complex set of investors in a corporation exactly who's entitled to what. That is what insolvency courts do, and Felix Stefik may want to come in here since he's a specialist in that area as well. But it's hard to see how an ISDS structure where one shareholder out of the entire group of stakeholders and a government is a well-designed forum to try to figure out what everybody in the whole stakeholder group is entitled to. The company is not there. It may oppose the action. The shareholder has no interest in disclosing company creditors. How is the tribunal even going to find out what the creditors, who the creditors are and what their rights are? So while there's considerable optimism, and we saw it in CAPES saying, we'll figure this out, the institutional structure of ISDS as a bilateral system between one shareholder, and it may be a selected shareholder if you look at the treaty shopping angle, trying to figure out what everybody's entitled to as if it were an insolvency court, no ability to appoint a receiver, no power over anyone who isn't a party. It's not a very well-designed system to try to sort that thing out. So if we were going to move to a model where we allow reflective loss claims generally, I think institutionally, we would need to do some thinking. And I think Sylvie mentioned, the Alicia Grace case. There's a creditor, a major creditor, at least alleged creditor of the company, says to the tribunal, which is one shareholder and the government, I want to get into the case. I have rights. If you give money to the shareholder, I'm going to be short-circuited. And the tribunal said, no. Well, one sort of understands why you might say no, because if you allow one creditor in, you maybe have to let them all in. And so again, I think, but to say to a creditor, not only can you be short-circuited, but you're not even in the room to advance your arguments. Only the shareholder is there and the government, which may not be a great spokesman for you. So I think Felix's point about, increased creditor risk when you see the ability of shareholders to exclude you essentially from what amounts to an insolvency type effort to distribute the loss amongst all the stakeholders is a significant issue.
Thanks very much, David. We have a question from Sergey on the chat, which Julian's going to start on, and then a question from Tom Sikora.
Great. Well, thank you, Sergey, for your question. The question is about what about minority shareholders and protection of minority shareholders? And the question was framed in a hypothetical where the majority shareholder might have treaty coverage, the company might, but the minority shareholder does not have treaty coverage. So what protection is available for the minority shareholder? And I think it's a important question, and one which I feel very strongly needs to be the premise of which I think needs to be rejected. So the issue is a question of whether this regime needs to be protecting minority shareholders. And it's not clear to me why it should be, right? I mean, the basic expectation of a minority shareholder is that you are not going to have control over your company, right? You are going to own some shares in a company. That company is going to do a bunch of things with its equity and with its money, which you hope that it does to make you money in the form of dividends or returns or increased share value. But you have given up your right to manage the company. That is, or you've never had that right. That's the deal with buying into a company with shares, right? That's the whole thing. Maybe controlling shareholders can exercise a little bit more, and that's a reason why some treaties protect controlling shareholders, but minority shareholders are along for the ride. And so I think it shifts the grounds of the basic expectations with how you deal with corporations to suddenly say that investment treaties should be protecting minority shareholders. Now, of course, they could be designed to do so. I don't see a particularly good economic reason to do so, or even a reason about access to justice. Why? Because the basic expectation is the company will cover your rights. The only exception I could see is if the company is tied up, right? If the company is somehow put into involuntary forced receivership in a way that's allegedly a breach of its rights, or if the company is totally expropriated, there might be reason to have residual claims available for minority shareholders or all shareholders in those very limited circumstances. But that's about it. And that's about all a minority shareholder should expect anywhere in the world.
Thanks, Julian. I also understood Sergei's question to cover a situation where the minority shareholder is, say, the only one with an IIA, an investment treaty claim. For example, they're in country A, which has an investment treaty, but the dominant shareholder and the enterprise are in countries B and C, and don't have, which countries they don't have treaties with the host state. So what about in that situation where one could argue that would potentially increases the coverage of treaties, but only unilaterally?
Sorry, yeah, I guess I guess I had it reversed, but even in that circumstance, just because a minority, an individual or a company from that nationality would have access to ISDS, there's still no reason to assume that just because you're a minority shareholder, you should have such access. There's not a sort of norm that ISDS jurisdiction should be expanded in all cases possible, right? These are bilateral treaties that exchange very limited rights to a limited class of investors, and there's no reason for that minority shareholder to think, based on the rights that they have in their shares, which are very limited, that they should have that special access to ISDS.
Thanks very much, Julian. We have now a question from Tom Sikora.
Hello, everyone, and thank you very much, Malcolm. This is for David. David, I think I understand the concerns that you have elucidated, but at the end of the day, it seems to me that it all goes back to first principles. And the first principles here are that the treaties are there to encourage investment, right? The treaties are there for the promotion and the protection of investment. And in very many situations, the investor is forced to invest through a local vehicle. So the actual local corporation does not have the ability to bring a claim. In very many situations, the investor is forced to invest with a local partner. And so the investor may not be a majority control investor in the vehicle. In modern material projects, which are often very large projects, the investor is not the sole investor. It is a group of investors. It is a group of companies because of the size of the project that is contemplated. And so none of the investors has control of the investment, and they're all from different states. And so it seems to me that focusing on preventing claims by minority shareholders can really be a disservice to the system of the promotion of investment. Look, there seems to me that there is a very limited, if any, risk of double recovery. No one has said that there are huge risks of double recovery being awarded, because in fact that's never happened. And cases by multiple subsidiaries are very rare, right? For many years, the only case that we knew about was the Lauder case. So it seems to me, David, that comparing this system, which has been created for a very good reason, to a system of domestic corporate law, which has completely different purposes behind it, is a bit of a red herring, isn't it, David?
David.
Great. Well, thank you. I mean, I think we're now engaging into the discussion. I mean, the first point, no one is forced to invest, right? There's no coercion here. There is a choice to invest under whatever conditions are available, and there's obviously some jurisdictions where you need a local entity and some where you may not, and you decide if you want to go into one that requires a local entity. So there's no issue of force or coercion. It's a choice to invest. I mean, I think it's similar to Sergey's question about whether it makes sense whether the costs and benefits make sense to protect the 30% shareholder using a general acceptance of reflective loss claims as a way to achieve that. And I think Felix Steffik's point that this rule likely will result over time in less overall investment, as Julian pointed out, suggests that, at that level, it's a questionable decision to single out some shareholders for highly preferential rights. Those preferential rights are difficult to defend in parliaments. Why are foreign shareholders able to sue the domestic shareholders sitting behind me, voters are excluded under our well-established law for lots of good reasons, and these foreign shareholders are allowed to sue. So the domestic shareholders are barred from claiming, and then as taxpayers, they're asked to pay for the damages award to their co-shareholder of the same company. That, I think, would be difficult to sustain in most democratic systems. So I think there's an issue of sustainability of any rule that would single out some. Are there cases where a government might want to give a 30% shareholder special protection? Maybe. But it would seem a better option, for example, to consider a framework within a treaty that would allow a government to approve protection for a particular investment that is particularly valuable and well-structured and meets goals, rather than having what's developed in ISDS, which is a free-for-all where every covered shareholder but no uncovered shareholder can claim. So I think, are there cases where it might make sense? Yes, maybe. I mean, the other 30% shareholder who's not covered may not be particularly impressed with the idea, but I think we could come up with some tailored solutions for governments to address these in a much more controlled fashion. You mentioned, groups of companies. These are typically in consortium type deals, as you say, but the shareholders, remember, are financial investors. They can mostly diversify the risk, right? They can invest 25% in 4 different projects. And if one goes belly up, they still benefit from high returns on the other 3. They can diversify the risk to a substantial degree. The operating company is the one that's in the jurisdiction. The people who are the trade creditors, the workers, the people who are affiliated with that company are the ones who have undiversifiable risk. So why one would say, oh, we're going to especially protect the people who can diversify their risk, put money into 4 different consortia in 4 different countries. If one of them, the government changes and goes off in a different path, okay, the project's in difficulty, but in the other 3, you're getting higher returns. So I don't think and again, the group of companies issue can be addressed under the notion of control, right? We've seen in Nafta that the scheme that allows for a derivative type claim is based on ownership or control, those terms are not defined, right? Which is a decision to leave that open to interpretation in various cases. But that could be defined in ways that bring in consortia, exclude consortia. Control can be defined in many different ways. Typically, it's defined in a way that seeks to advance the purposes of the particular context where it's defined, but it can range anywhere from under 10% up to, majority plus one. So I think, you raise important issues. I'm not saying that those interests are not important to be protected, but I think there's a strong argument to say that those interests are far better protected through some form of company recovery regime where it's appropriate. And that's a question of, the scope of ISDS and treaties and so on. But where you want to protect, you protect the company, and then everyone is protected. You don't single out one subset of largely financial investors and say, okay, you get special protection over and above the others. But it's an open question, and we're very happy to engage in the debate and get the input from a wide range of sources.
Thanks very much, David. And I'll give now the word to Anna from OECD to conclude our discussion, which turns out not to be so technical in the end, but ranges a range of systematic and deep policy issues. Anna.
Okay, thanks a lot. I think that, thanks all of you. I think that you did a great job in terms of the presentation and exchange of views. Also very interesting question. I'm very glad that with UNCITRAL and with the academic forum, we were able to provide this kind of platform. I think that in the discussion today, we have observed that this topic is relevant for many issues. I took some note, and I think that this has ramification in different procedural concerns that have been identified by this working group. The working group 3 of UNCITRAL have impact other aspects such creditors and investors that were mentioned also by Julian, and it has consequence in government budget. I think that David raised this issue of dispute cost. It has been very important, this platform, because I think that raise awareness is important. I think that this is was very clear here. Also understand the ramification. You did a good job on that too. And also I appreciated that Julian and Sylvie, you presented some kind of solutions. I think that we could move, like maybe in the future, like a little of understanding the discussion that we have right now in terms of all shareholders out, what kind of the kind of solution mind, and see if we can find in this process some kind of reform and solving solution mind setting. Just a final remark, I need to say that I think that the reform on investor state dispute settlement are very important, and I'm super glad that UNCITRAL has taken this seriously, and all delegates here are engaged on that. But I have to say that I think that if we want to really change and balance the system in terms of investment protection and right to regulate, we need to also tackle reforms in substantive provisions. And this is something that we have been working, different international organizations are working on thinking a little more about the other part of the reforms. And I think that the collaboration among different international organizations where we have the same delegate or similar delegates, and then if we join forces, it demonstrates that it's very, very useful for move the agenda forward. That's are my last remarks.
Thanks very much, Anna, and thanks to all of the panel and UNCITRAL, OECD, and the Academic Forum for today's event. We'll be taking a break from the informational webinars for a month or so, but we'll be back, I'm sure, in August with the next event. Wish everybody a good evening, a good day, or a good night, or wherever you are in the world. Thanks again for tuning in, and we hope the discussion on shareholder claims and double recovery has enlightened more than confused. Thanks to everybody.